Hello, everyone. My name is Andrew Feldstein, and I'm the Andrew of Ask Andrew. I'm a family law lawyer and divorce lawyer. My main office is in Markham, Ontario, just north of Toronto, and we have 4 other offices in the Greater Toronto area. Now, unfortunately, we are having some more technical problems here. I'll confess that I usually use a teleprompter. Tonight, at least for the opening segment, it seems to be giving me some challenges. So I want to say the show is being broadcast live for those of you who are watching it now, and for those of you who are watching it in the future. Today is September 15th, and it will be saved on our website at separation.ca for those of you who miss us live. Or if you found some interesting information tonight and you want to hear it again because it may be helpful to your family law issues, you can know to watch it that way. And this is season 1, episode 8, and that's how it will be archived if you want to watch it in the future. Now, if you are watching it live, we welcome your telephone calls, text messages, or emails. All the information you need to reach us is on the banner at the bottom of your screen. So please, I invite you to contact us. And it's, I tend to think a pretty rare thing where you have a lawyer inviting you to call in and ask questions for free. So lastly, in my opening statement, I want to say that there's an important word about privacy. If you type in a comment on Facebook Live, that comment and your name are immediately available for the world to see. And they remain on the internet forever. If you phone in with a question or send a text or an email to the addresses that are at the banner ad at the bottom of your screen, your identity information is not published. So please phrase your questions with your privacy in mind. I'm not going to use any names that can allow a person to be identified, because obviously we want to maintain confidentiality, unless of course you're using Facebook Live. The show is starting a little early tonight and ending a little early. My apologies. I have some personal things I have to attend to tonight, and I had to move the time around a bit. We're going to try and get to all your phone-in questions, text messages, emails, Facebook Live comments. Last Wednesday, I did a radio interview in Toronto with Barb DiGiulio on the Night Side, which is on News Talk 1010 Radio, and it's a great show for those of you who like to listen at that hour. The focus was on the spike in separations and divorces starting in September, just as the kids go back to school. And in my view, 2 factors seem to come into play. With holidays, both parents often spend more time together and realize the relationship just is not working. And September always seems to have a sense of renewal to it. It's the month when people say, let's get on with their lives. It's the month when kids go back to school and start a new year. And a big thing of getting on with your life is when you are in a relationship that you're not happy with, is deciding to end that relationship, whether if you're living together with someone in separation or if you're married and it's a divorce. Your phone calls do not all have to be questions. Please call in if you have insights you'd like to share about starting your own separation, or at any time of the year, whether it's September or some other point. Now, let's get to tonight's show, started with questions we received by email. As always, it's always encouraging when people are sending their emails in advance so that we're ready to get started with the show before any phone calls or emails or text messages come in. Now, the first question that I received is, I want to start a business. Every time I pick up a newspaper or magazine, I see stories about how being an entrepreneur means financial and personal success. I plan to divorce my husband of 15 years. Our kids are 13 and 11. If I become an entrepreneur, I'll be able to support myself. Instead of getting alimony every month for years, can I ask the judge to make my husband give me $250,000 of the alimony money in one chunk and only pay me half the money of alimony after that to balance the advance? Then I can start a party planning business. I would need a car for me to use on sales calls, a truck to transport decorations and catering where the events are held. I'd use some of the money to pay my sister to help me part-time, and I need some of the money for me and the children to live on while the business was getting established. I think this is actually a great question. Obviously, being an entrepreneur is something that's great for the economy, but the irony is when you're about to go through a divorce, and you want to decide to be an entrepreneur, it can be a challenging thing because this person wants to be creative and have lump sum support up front and alimony later on. I would be shocked if someone who is the payor and married to this person would agree to that. And the only way that that's going to really happen is by an agreement. No court on these facts would order a lump sum support payment. Why do I say that? Because a court starts with support being paid on a monthly basis. The logic for that is fairly simple. Your support is being paid based on the income of the parties. Incomes can go up, incomes can go down. When somebody's income can go up, it can be a change that requires, in spousal support and material change, it require more spousal support. And in child support, there's an annual review under the guidelines. And when that happens, your child support will go up or down depending on your income. So as a payor, you're going to be very reluctant to pay a lump sum amount up front unless you think there's an advantage to it, i.e. less money, or you believe your money's going up. In this case, this person wants a lump sum to start a business. They're also going to face a problem when they say they want to start a business, is that if they're currently working, their spouse is going to say, well, I don't want to pay spousal support based on your startup income, which may be nothing or $10,000. If I have to pay support, I want it to be based on your actual income. And they're going to say to a judge, if I have to pay support, they can go start their business, but support should be based on their actual income. So you have to be very smart with what you're doing. And the irony about this is, where I see this issue coming up a lot, is somebody has a decent job and they separate and they want to quit their job because they think they got a good opportunity to start a business. The person on the other side who may be receiving support will then say, you should have never quit your job and I want support as if you didn't quit. And most likely a court is going to say, yeah, you shouldn't have quit your job, and make you pay support at the higher number. It may sound surprising and unfortunate, but that's the way it is. And the great irony of that particular fact pattern is, if you actually are the successful entrepreneur and you start to make more money than you did when you were working, your spouse is going to want a piece of that too. And not participate in the lean years, but just participate in the active years where you've been successful. So there are some real challenges. And I think this person in this particular fact pattern, they're not going to get that lump sum payment. If they weren't working and they're unemployed and they were raising the children, then starting a business may be a great idea. But I query whether they should be putting that kind of resources into the business. And at some point, a court will say that they need to start making money for support purposes. I just received our first text question of the night. And the question is child support based solely on income? And I like that question. And to answer it, it depends. And it depends on certain facts. So it does depend on income, but it also depends on the residence of the children. So if my child is living with me more than 60% of the time, then my spouse's income determines child support, the table child support. So you would look at their income, you would then see what the table says, and they pay that as basic child support. If we are in a shared, meaning we each are more than 40% of the time, then the calculation is based on both of our incomes. In other words, I would have to pay based on my income, my spouse would have to pay on her income, and we would look to the same guideline, and whoever has to pay more would pay the difference. But that would only be the starting point. After that, we would have to look at the conditions, means, needs, and other circumstances of the parties to determine whether it should be more than what we would call the set-off child support, all the way up to the full guideline payment. And there's a lengthy analysis of child care budgets that become important in that scenario to see whether you do set-off, somewhere between set-off and full table or full table. And then lastly, there's another regime called split custody. Split custody is when, for example, if I'm divorced and one child lives with me more than 60% of the time, and my other child lives with my former spouse more than 60% of the time. In that scenario, it will be a set-off according to the statute, period, end of story, and that's based on your incomes. The next place that you go to is called Section 7 expenses. And Section 7 expenses are special and extraordinary expenses. What can be special and extraordinary? Well, some are really, really easy, and some are really, really obvious. The easy ones, daycare, post-secondary expenses, medical expenses over, I believe it's $100. Those are easy ones. The hard ones depend on extracurricular activities, private school if children have never been in private school, and sometimes we get to fight over what these are. And in that scenario, the guidelines say if the expense is reasonable and necessary, then you would look at both parties' incomes, add them up, and you would do it based on the percentage of each party's income. So if the husband makes $70,000 and the wife makes $30,000, the husband would be responsible for 70% of that expenses on an after-tax basis if you're dealing with things like daycare. The only change in that particular item, in that rule, is that spousal support would be removed from the payor side of the equation and added to the recipient, but not child support. Child support would stay where it was. Hoping I'm not confusing you with that, but there's a mixing of income and percentages and table support and the extras. Now, we just got our first Facebook question of the night, and that is, what would you advise a person to do to ensure that while in a legal case, they properly document everything for the courts? That's always a challenge, because what is everything? I strongly recommend clients, when they're having communication with their former spouses, when it's something of a contested nature, it's a good idea to have a written record of it. It means send things by email. Make sure you save the emails. If there's an allegation that you can't cooperate or can't get along, then maybe save all the emails showing that you can get along. If somebody is being rude, vindictive, showing that they can't co-parent very well, make sure you save those emails and have a good place to save them. At the very least, you want to save them in multiple locations. So if you've saved it in your hard drive on your computer, save it in the cloud as well. Make sure that your passwords are protected, because there's always a fear that our former spouse may know what our passwords are. So if your password is your child's birthday or things of that nature, you have to come up with something completely creative that you know your former spouse will have no idea, no way to guess. If you think printing it out is a good idea, it is, but do not solely rely on it. And I'll tell you why you can't solely rely on printouts. Number one, they can be lost. Number two, there can be a fire. Number three, you might think you could take that printout to the person you can trust most in the world, like your best friend. And I'll never forget, I had a case where a woman came in and said, Andrew, I got all the great evidence on how my husband is hiding money and all the cash he's doing. And I said, great. I said, did you take it out of the house? Yeah, I gave it to my best friend and she's keeping it. A week later, she comes into my office and says, Andrew, I don't have any of the documents. And I say, what happened? She goes, my best friend was having an affair with my husband and she destroyed it all. The point that I'm getting at is you can't trust somebody with your passwords. You can't trust somebody with your documents. And if you're going to put it somewhere, you better make sure it's secure. And if you can have multiple locations, like a safety deposit box and in the cloud, do that. And make sure you're documenting as much as you can. Okay. Our next Facebook question is, if I'm thinking of getting a divorce, but I have to leave town a lot for work and leave the kids with my spouse, if we start a divorce, should I stay home or will I lose custody because I'm not there often? There's a few things in there. Number one, courts do look at the historical status quo, which means what's happened before the separation. So if I travel a lot for business and I'm just not there, it's hard for me to argue I'm an equal caregiver with my spouse when I'm on the road 5 days a week. It just is. And that's going to create an uphill battle to convince a judge that you should be able to have equal time or be the primary caregiver. This person refers to it as custody. Custody is a fight really over decision-making. It's school, education, religion, mobility. There are fewer and fewer cases where we fight about that issue, and most people are quick to get to joint custody. And more cases, what we fight about is what's the schedule for the child, because that's really what's important. Where are the kids going to be living? How often are they going to see each other? And people can have a joint custody regime with one person being primary caregiver. And that's what they fight about. And in this person's scenario, traveling will hurt them. And if they change after separation, it may be something to be commended, providing it doesn't hurt their their income. But the downfall is they have that history, and the history may come back to haunt them. Some judges may say, well, let's give them a chance. Other judges won't. If I was thinking I may want to start a divorce and I travel a lot for work, I would want to hold off on the divorce and change my schedule. If I'm a father, I want to be super dad. If I'm a mother, I want to be super mom. That means I probably would want to go to my spouse and say, you know, I haven't been here much lately. I'm going to be working more from home over the next 6 months. When I'm home, I want to do pick up and drop off. Start going to the doctor's appointments and dentist appointments. Make sure you go to the baseball games, hockey games, dance, gymnastics. Do everything that you can. Be there with your children. Spend lots of time with the children, because then you've changed the narrative for the separation and can say, if you've done that 6 months, a year, 2 years, I'm an equal caregiver. And your bonding with the child will be that much stronger if you have to go to third parties to help out. Now, the next Facebook question that we have here is, can you take a father to court for retroactive child support? My kids are 14 and 18. Well, child support is considered the right of the child, but you need to make a request for child support. And this, I'm assuming in this question, it doesn't say it, that there is no agreement, there is no court order. And if there is no agreement, no court order, you have to make a request. And the request doesn't have to be a court action. It had to be in writing, could have been an email. Sometimes there's a fight because one person says, well, I asked for it verbally several times and they said, I'm not going to pay it. Courts are usually pretty sympathetic that parents need child support. So it depends on the circumstances. If there is an agreement that's in writing, there's usually a clause that says child support is to be reviewed every year. And there's usually an obligation, because there's a legal obligation on the payor to give annual financial disclosure to the person who receives child support. And if they ignore that obligation, that makes it much stronger for retroactive support. In many cases, the retroactive support may even go 3 years prior to the date of the first request. And if there's something called bad faith conduct, it can go back all the way to the beginning. With bad faith conduct, if there's a court order and agreement for disclosure and you haven't done it, that may very well be bad faith. The other interesting comment that I have from this question is this person's children, 14 and 18. If the child is 18 years old and you're making your first request for child support, and that child is no longer what we would call a child of the marriage or a child under the Family Law Act, because the child is not in school on a full-time basis, then you may have a problem, because if your child is not a child and you didn't ask for child support before, and there's no agreement and there's no court order, then you're in a position you may have missed the limitation period to make the request for child support. So you have to be very careful to make sure you make that request. How do you solve this problem? Do it in writing. Send several emails to your spouse saying, I want my child support. Give me your income disclosure so I can pay child support. And if they ignore it, they're ignoring it at their own peril. But understand, you got to do it before the child is no longer a child. In Canada, under the Divorce Act, you're considered a child of the marriage if you're under 18. And then there's certain exceptions that can extend it to an older age. For example, being in school full time. That's an easy one. At least one undergraduate degree. And in some cases, the payor has to also pay for at least contribute to a second degree. Maybe not the table child support, but at least helping out with the degree. So make the request on time. I'm going to move on to the next Facebook question we have. Should I make my social media accounts private while I'm going through a divorce? That's an easy answer. Absolutely, you should make it private. I've done a lot of media interviews, and it seems to be a hot topic that the media really enjoys, is talking about social media. And I always think that there's one case out west where a father goes onto Facebook and he just reams out the mother on his Facebook feed. And his child is one of his Facebook friends. And the court interpreted that as saying, mom should get custody because dad is posting all of these heinous materials about mom for the child to read. Not good. Not positive way to parent your child. You also have to think about the other things on Facebook. And it's interesting because on Facebook, people like to show off their life. the nice things they're doing. Sometimes they try to make life look better than it actually is. I know on my feed sometimes I'll see people, you would think they're living a movie star life of travel and riches, because that's what every picture portrays. But picture when you're going through a separation and you're telling your spouse, my business is bad, I'm struggling, I'm fighting hard to make a living, but yet you have the pictures of your fancy vacations. You know that spouse is going on Facebook and printing off and saving all of those posts that make you look like you're living up a high life. You got to think about it. And you may think, well, I blanked out my spouse for my Facebook account. They can't see me. You know what? If you have 500, 700, even 100 Facebook friends, what's the likelihood that just one of them is good enough friends with your former spouse that they're going to constantly be printing off this material and forwarding it over to your spouse? And if they're going to do that, it's now open season. So one of the things we as people have to do, and I know I talk to other people about this all the time, is that this invention, our cell phones, that make it so easy for us to communicate, to post on social media, are also the great problem for us, because we make it too easy to communicate. And in the past, people were used to, if they had a problem with their former spouse, they'd sit with their friends and families and they would complain. And if you complain on the phone, and especially if your kids can't hear and they're not, or even better, they're not in the house, and you're sitting there and you're complaining about them, nobody needs to hear it. Nobody's going to know it. Your kids aren't going to hear it. But if you do that same thing in social media, you're posting it for the whole world to see. And very few people have few enough friends that they can do that. So I wouldn't just mark my accounts private. I would not say anything about my divorce. If you want to say, I negotiated a successful agreement today with my spouse, great. I got divorced today, great. Beyond that, don't say anything, because whatever you post, even if you give her a compliment or him a compliment, and then later on you're complaining about them, you may turn to Facebook and say, well, you said I was a great parent on Facebook. So just assume every post your spouse is going to read and will see, and the judge will read it and see it. Is that something you're going to feel proud about? Is that something you're going to want to see? How would you feel if that was on the front page of a national newspaper like the Globe and Mail? Think about that before you post. I know it may have been a little bit of a rant that I just did, but there is nothing as awful as negative social media. And it reminds me, I've told this story, I probably haven't said it here on the Ask Andrew show, but it's an example of how to make a mistake. One of my clients would have a spouse who would phone him and make really demanding voicemail messages. And he really didn't like them, and it would get him angry. And he's a little bit of a computer guy. So he set up a website with a talking monkey. And he used the wife's voice on the talking monkey with her messages, with images to make fun of her. And that's the kind of thing that if you're doing it in the privacy of your home, talking to your friends, and your kids aren't there, great. It may be funny, it may not be appropriate, but it may be funny among your friends. But to put it on social media, I know I said to my client as soon as I saw it, get it down, and let's hope she didn't see it. Because if she saw it, think of the damage you're doing to your case. Picture a judge who sees that. You got to picture yourself in a courtroom in front of a judge, and the judge seeing the talking monkey. And then you're trying to say, but Your Honor, I want to co-parent and I can get along with this person. Yeah, but you're the guy who posted the talking monkey. And that's all that picture the image of the judge. The judge who sees all these cases all the time and deals with all sorts of family law disputes. Do you think the talking monkey is going to be a memorable one for the judge? I still remember it 10 years later. So if you're going to do something like that, not only is it damaging, but it makes it really memorable. And if it's making it memorable that way, that's going to be the focus of your case. So don't make those kind of mistakes. Resist it. Get it out of your system by using your mouth, talking to your friends and family that aren't friends and family of your wives or your husbands, and make sure you're not putting it out there where it's out there for everybody to see. Okay, I know that's a rant, but it's just one of those really foolish mistakes people make, and you shouldn't do it. And the last thing I'm going to say is Picture when you say you're disabled. I mean, another example, part of my rant. Picture you say, I can't work. I'm physically unable to. And then there's your pictures of you out dancing it up different nights, partying, having fun, but you're not well enough to work. I've had those cases, and just don't do it. Don't. I mean, yeah, even an obvious one. I've seen people deny that they're working, but their LinkedIn profile shows that they are working. I mean, people are going to check these things. We're going to look at these things. Anyways, it's time for me to move on. I know it's a rant, but it just drives me crazy. But as a lawyer, the last thing I'm going to say on this, I love it when the other side does, because I rub my hands together and I say, thank you for the gift. Now, my next Facebook question is, how likely is it for a court to grant me retroactive Section 7 child care payments if no payments have been made for over 6 months? Okay, I was talking about Section 7 payments before, but this person really is saying is they had their child in daycare and the other spouse hasn't paid for it for the last 6 months and they want to get it back. That's an easy one. When I've been in court, somebody will say, well, I never agreed to daycares. And usually Section 7 expenses need to be agreed to in advance in writing by the other side. But it's important for you to work. And if you actually have a job and you're working and you need daycare for your child, well, that's a pretty obvious one. And the court isn't going to say your other spouse had to agree if it's a reasonably priced daycare. I mean, if you're going to a really expensive daycare, that may be an issue. But if you're at the normal prices, you're going to get it. And you're going to get it every time. The judge will turn to the spouse and say, you knew your child was in daycare. You're picking your child up there. Who do you think was paying for it? You know, it's sort of like if you had a car and you have a lease payment, it's supposed to come out of your bank account every month. And then for 4 months, it doesn't come out of the bank account. And then all of a sudden, the company that you're leasing the car from comes to you and says, pay me the last 4 months. What are you going to say? Well, it didn't come out of my bank account. You knew it had to be paid for. You knew the time is going to come around and you got to pay. And when that happens, you pay because that's your responsibility. So with daycare, it's the same thing. One of the arguments I've heard with daycare that sometimes drives people crazy is they will say, well, why should I pay for daycare? My new girlfriend, my new spouse, my parent can care for the child during the day. And most courts are not thrilled with that concept. I mean, can you imagine when you are in a situation that you've separated and you're a parent, and whether you're the husband or the wife, and the other spouse wants their new partner to be the daycare provider? That's a pretty awkward thing. And I have never seen a court say, yeah, that's a great idea. Let's do it. Courts aren't going to buy into that. Some people think it's a great idea. They're just not going to buy into it. If two people want to do that together because they agree to it, fine. Sometimes people have suggested, you know, my mother, my father will be the daycare provider during the day. And they don't understand why the other side doesn't want it. Well, sometimes, you know, divorces bring conflict. And generally speaking, the daycare provider who's taking care of that child Monday to Friday, 9 to 5, while you're off at work, should not necessarily be the other person's parent unless it's consensual, because that may just inflame the conflict more. Remember, parents love their children. That usually means they're not very objective. It usually means they believe in the truth and justice of their child's way over their former spouse. And that can create a problem and can create hostility. So generally speaking, yes, you're going to get the Section 7. It's going to be pretty straightforward. Next text question that I got is this. Is it ever possible to meet with a judge if you feel your lawyer has made serious mistakes in court? Okay? A person cannot meet with a judge alone. I'm a lawyer. I act all the time. I am not permitted to go meet with a judge alone about another case. You can't do it. You don't talk to a judge about your case. The idea of our court system is that it's supposed to be open. What does that mean? It means if I am on a case and I'm acting for a client, I'm going in front of that judge, typically with the other side present, their lawyer or unrepresented just then. I'm allowed to bring a motion, sometimes without notice to the other side, so I can go talk to the judge, except That's going to be typically in a courtroom with a court reporter present. So there's a record of the communication. And then afterwards, I actually have to serve all my court materials in court and what the judge ordered that day. And according to the family law rules, that matter needs to come back to court within 14 days. So it's not as if I can go in, you can go in and say, well, my lawyer made serious mistakes. If your lawyer made mistakes, then maybe you need to talk to another lawyer about what to do about it. But it's not for you to set up a meeting with the judge to take the judge through how your lawyer made mistakes. It just doesn't work that way. Okay, I think I've caught up to my Facebook and text questions now. So I'm going to go back for a bit to the emails that we received before the show. And here's question 2, and this person titled it, "No Singing Aloud." You probably saw a story in the paper last week saying a father would not let his children stay in the classroom when music lessons were taught. My husband is not this strict as far as school music class goes. Besides, we don't have a way of getting our kids out of school for an hour each in the middle of the day. But outside of school hours, my husband does not allow them to be in the school band or choir and can't be in plays or anything on a stage. And they can't listen to music at home. I want them to enjoy music and drama just like other Canadian children. Is there a way to get a policeman to tell my husband he's not allowed to be this strict in Canada? Well, I'm going to start with each parent gets parenting time in the ordinary course. And if each parent gets parenting time, well, the children is in their care. They're responsible for the child and they get to make decisions for the child. And that means if they don't want music on in their home because it gives them a headache, they're entitled to do that. And when the children are in your home and you want it to be a warm home that has music on all the time, you can do that. You can't control your other spouse. And one of the things in here that you talk about, can a policeman or a policewoman for that matter speak to you? They don't want to get involved in this kind of dispute. And there's a problem in the logic, and I see this from clients when they come in, and it's one of the things you see junior lawyers do. People will frequently say, well, let's get police enforcement of a court order. What if I go to pick up my child and my child's not available and I want the police enforcement? If you go to court and ask for a court order to be enforced by the police, and it's usually junior lawyers who do this initially, the judge is going to be very upset. Because can you imagine if I go to pick up my children, okay, I'll give an example. I have my kids on Monday night, I go to pick them up at my ex-wife's home. I knock on the door and they're not there. I don't know, they're late coming home, something happened. I pick up the phone and I call the police. Now the police come over to talk to my children's mother about dealing with the mother. And they're not going to want to see the police dealing with their mother. So where do we go from there? Courts don't want to make orders for police enforcement. They're not going to have police speak to the father about music. They're not even going to talk to the father to say that there's going to be music. And eventually, if a child prefers one home over the other because they like the style of that home, so be it. But the police aren't going to be involved. When is there police enforcement in family law, you might ask? Police enforcement is when there's a history of breaches. And it doesn't mean, oh, somebody was 15 minutes late for a visit or 15 minutes late for a pickup. What it means is, picture, I go to pick up my kids on that Monday and I ring the doorbell. My ex-wife comes to the door and says, you can't have the kids. And I say, but there's a court order that says it's my time. And I says, I don't care. I'm not giving you the kids. Okay. Now you're going to have to go to court. You might bring a motion for contempt, and you may ask the court for an order for police enforcement after there's been breaches. It's the same way some people in cases with conflict say, let's have the access exchange at a police station. How many times I've heard that from clients in my career. And I turn to them and say, do you appreciate the message you're saying to your children? That I don't trust the other parent so much that the only way you can walk from me to them is if the police are here to monitor it. That's a problem. Because most people should be able to pull up at their former spouse's home, text them that they're there, text if the kids have a phone, text the kids if the kids are younger, if they're really young, ring the doorbell, don't speak, pick up the child and leave, and vice versa. Those are things that should be able to happen. Put your kids first. Love your children. Don't get into these silly type of issues that require police involvement. Now I'm going to move to the next Facebook question that just came in. The visiting parent is demanding that he can bring his family/new wife to access visits. The visits are supervised by the mother as the child does not know him or understand the language. There's a language barrier. Can that be refused since access visits are for him to get to know the child and bond? And there's no bond between them yet? Well, it sounds like things are at a very early stage in that case. And if they're at a very early stage, if there's a court order for access, I could not imagine a judge saying the new partner gets to be there. Right now, it's all about bonding with the, in this case, it's the father. If there is a court order in this type of fact pattern, I would think a court would be very sympathetic of the position of mom, because it seems pretty outrageous that dad wants to bring his new partner into mom's home and exercise the access there. I will say this, though. I'm going to take it into a broader context, because sometimes you get this question, is what happens when we go beyond, how should I put it? When someone wants to introduce their children to a new partner, okay? And this happens. It's a certain time after the separation and somebody says, now I want my kids to meet my new partner. It's an important person in my life. They should meet them. What's the right time? Well, you certainly don't do it after 2, 3, or 4 dates. There has to be a number of months of dating. You want to make sure it's a stable relationship, one that appears to be long-term, and somebody you want your kids to meet. When you've reached that point in time, that's fine to introduce the kids, but you got to be sensitive to your children's needs. Your former spouse cannot complain that you're doing that. But if you try to do it after 2 dates, it's going to be a legitimate complaint. At the end of the day, you're going to pay a price. And the price you're going to pay for introducing a child too early is going to impact the relationship with you and your children, and probably the new partner if they don't like her or him. So you need to think about that. You need to be realistic about that. Lastly, some people really want to try and control the kids. And somebody will ask a new partner to pick up the children at school. You shouldn't be doing it every time. But every so often, once every 2-3 months, I'm running late from work. You phone the new partner, can you pick up my child? That's perfectly fine in most cases. And as the former spouse, you shouldn't be complaining about that. Now, I'm going to go back to an email question now. This is about destination weddings. And this person says, I hate to be a pessimist, but I did not think my first marriage would end in divorce, so I want to be careful with marriage number 2. Our plan is to get married on a cruise ship in the Caribbean this winter. Does getting married on the high seas mean anything is different as far as marriage law goes? If we do get separated, will Ontario law still apply? Is the wedding date considered the real day or the day we came back to Ontario? Well, we're actually under marriage is not Ontario law, but it's federal law. And in order to be divorced, you have to be married. And for us to recognize a marriage, we go to the Marriage Act, and we recognize marriages that take place in other jurisdictions, providing we comply with that jurisdiction's law. I'm not going to profess to say I'm a maritime lawyer, but I believe that means if you got married on the high seas, you'd be married under the flag of the country that the ship is in. And if that's the case, you'd have to comply with their laws for marriage and Canadian laws. If you're complying with both, it will be a legal marriage. And that means you'll be under Ontario law for property regime and Canadian laws for custody, access, child support, and spousal support if you elect to use that over Ontario laws. Okay. The next question we received in advance was, my wife and I have been married for 22 years. We live in Toronto and have 3 children. Our boy is 20 at university and is Sisters are 14 and 17 in high school. She wants to move back to Winnipeg with the girls and live with her parents. She wants me to pay child and spouse support as listed on the Ontario Manitoba government websites for all 3 children, whichever province is higher. She says she'll send money on to the boy. Will a judge force me to send all this money to Winnipeg when I can't even see 2 of the kids unless I drive 5,000 kilometers per round trip? Can I get a court ruling that requires my son to live with me in the house we now have, and then I don't have to pay any child support if I continue to look after him as I have in the past? Well, the first thing I'm going to start at is the age. You have a 20-year-old. 20-year-old, if they're living here and going to university, is staying. The real question is he going to stay in the house with you, or is he going to live on his own? And then where is he going to be in the summer? Is he going to want to be with mom? Is he going to want to be with you? He's going to choose this fate. You're 17-year-old. Same thing. At 17, you're really not going to be able to tell the child where to go. 14-year-old is a harder question because it's a maybe. And you may want to say you don't want the children to leave. And the children, mom may want to move to Winnipeg, but if you can offer a reasonable place for them here, I'd be surprised that a 17-year-old and 14-year-old would want to leave Toronto, their friends, their high school, their lives, to go to Winnipeg. Your best strategy is to say, they're not going. I want them to stay with me. But I can tell you, the 17-year-old is going to decide on their own. And it may be hard to stop the 14-year-old if they want to go along with the 17-year-old. Now, what does that mean? You raise a question about child support and spouse support. If kids stay with you, mom, the person leaving the mom may have to pay you child support. And you may be able to impute her to an income if she quits her job here to go to Winnipeg. However, if the children go to Winnipeg, you are going to have to pay child support, and you may very well have to pay spousal support. You could try and argue that the high cost of exercising time with the children is something that creates an undue hardship for you to reduce your cable child support. Odds are you will lose on that argument because in order to advance that argument, you have to pass a mathematical test on the standard of living, and there needs to be a very large income where you have a lot less than they do in order for you to succeed on that. I can't even begin to explain the calculation because it's so complex. I don't know anyone who can do it by hand, and it has to be done with software. The argument you may have is that the cost of the children coming here or you going to visit is a special and extraordinary expense that should be shared proportionately by the parties, or even argue it's one of the rare cases where it shouldn't be proportionate. And a judge may be somewhat sympathetic to that. The other place a judge may be sympathetic is that if you have to pay spousal support, under the spousal support advisory guidelines, there's a low, there's a mid, there's a high. And you may be able to persuade a judge in this situation, the low is a much better number because you have a high cost just to see your kids. I hope that helps you answer that question.